Well, hello and good morning. Welcome to Sunday Morning Coffee with Dr. Childress. Today I'm going to be discussing Kayden's Law. That's a law that's going through several states, many states, probably all states, restricting what the court can do in child custody cases. And there's a lot of secrets surrounding Kayden's Law. And it behooves everyone to know exactly what the law is doing because there's a group of people, a group of litigants and their allies who are biasing child custody cases in the favor of one of the litigants and to the disadvantage of the other. And it's a feature of the pathology. It's the borderline mom pathology with the persecutory delusions is manipulating the legislatures into supporting the delusional thought disorder and participating in the child abuse. So that's very interesting. So today I'm going to talk about the secrets of Kayden's Law and that what you don't know will harm the children. So it's very important people know what's in Kayden's Law. So this past week, I attended a seminar from the AFCC, the Association of Family and Conciliation Courts. That's the professional organization of all the family law attorneys and forensic psychologists. And so they had a seminar from Bronstein, Deutsch, and Polak regarding Kayden's Law, Truth and Consequences of Kayden's Law, Emerging Trends. So in today's Sunday Coffee Talk, I'll be talking about what they presented and their concerns, and they are my concerns additionally, but I'll be focusing on three areas relative to the problematic issues in Kayden's Law. Now, this is from the slides of the AFCC. And so you can see the states that have Kayden's Law passed as Arizona, California, Colorado, Maryland, New Hampshire, Pennsylvania, Tennessee, and Utah, with other states coming because there's federal money attached to it. They got it through Violence Against Women's Act. They hid it away so that nobody knew what was coming through, and they gave money to incentivize states to pass the law. And so we got some who, now I would argue that all of these states are participating in child abuse. Okay, all the state legislatures who pass this are participating in the psychological abuse of children because they don't understand what they just passed. So, but we'll talk about that. We'll see what's up. So, let's see. So there, just to begin with, just basically, there's two variants of the pathology in the family courts. One is typically the narcissistic dad. Now, it's not totally gender aligned like this, but it's the prevalence, you can think of it this way. So we have the narcissistic dad version. That's the Dark Triad personality: narcissistic, psychopathic, and Machiavellian levels of manipulation. And then you have the borderline mom variant. That's the vulnerable Dark Triad. And that's the one who's written this legislation, is that variant of the pathology. And that's vulnerable narcissism, psychopathic manipulation, type 2 psychopathy, and borderline personality pathology. So that's the one that's written the legislation. And what it does is it imposes enforced bias in custody conflicts in favor of one litigant, the borderline vulnerable Dark Triad parent, to the detriment of normal range fathers. And so let me point this out for a second. All you dads groups out there, Kayden's Law just decimated you. It took away all your experts and prevents you from even defending yourself in any way, and just mandated. So oh boy, you dads group, you just missed it because Kayden's law was moved in as a secret. No one knew. No one got to pay attention to it. They just got it in, got the money, and the forensic psychologists are a little upset about that. And I'll explain why. So right now, with all the states who have passed Kayden's law, there is an imposed bias on all custody evaluations in favor of one litigant and to the detriment of the other litigant. It was included, this Kayden's law, secretly into the Violence Against Women's Act, not a court custody related bill. So notice what they did. They got it into a domestic violence bill because that's the borderline mom. She's got the persecutory belief system, and she's tossing out that domestic violence allegation to manipulate everybody and to get virtuous victim presentation, to get everybody taking care of her and protecting her and the child and everything, because it's a persecutory delusion. So they manipulated, got it into the Violence Against Women's Act, where nobody was paying attention from the family courts. That has nothing to do with the family courts. Don't tell anybody. We get it in and get it into the state legislatures, and don't tell anybody. Family secrets. Oh, that's a classic symptom of sex abuse. Family secrets, and that's what's happening. Secrecy around these laws, and we need open hearings about this. We need to get people who disagree to present to the legislatures, and there's plenty who will disagree with the Kayden's law. So then it's incredibly manipulative because it's seeking to prevent debate and discussion and prevent treatment. Oh my goodness, this is Machiavellian levels of manipulation with Kayden's law. So here's the three issues that I'll discuss today. First, it requires no treatment is provided for severe attachment pathology. So let me be clear on this. Kayden's law requires that no treatment is provided to severe attachment pathology. That's number one, because the borderline mom is creating the attachment pathology and she doesn't want it fixed. She wants the pathology in the child. So they have mandated that no treatment can be done for the child. Well, watch, I'll tell you. The second thing it does that we'll talk about is it requires that children are not protected from psychological child abuse by a borderline vulnerable dark triad parent. So it requires protection for physical abuse and sexual abuse and leaves out psychological child abuse. So there is nothing, we cannot protectively separate a child from an abusive borderline mom. We are prevented by statute. So all of those states who have passed this cannot protect children from psychological abuse by a borderline vulnerable dark triad mother. You cannot do it by your statutes. Wow. So we're going to have a lot of abused children in your states by these borderline moms, and there's nothing you can do about it. You can't treat it. You can't, nothing. There's nothing you can do. So you can't protect the child. My goodness. Okay. And the third thing it does is it eliminates all expert testimony except the domestic violence allies of the borderline vulnerable dark triad parent. And this is a part that has the forensic psychologists particularly upset because they are eliminated as experts in the family courts. All the forensic psychologists, I'll explain why. They're eliminated, and there's no experts about parental alienation. Those are eliminated. So you dads, you normal range dads, you have no experts. They can call their domestic violence experts and do all that stuff, but you have zero experts, and you can't it prohibits you from making an argument about parental alienation. So that's gone. And the forensic psychologists, I don't know what they're going to do because they're no longer allowed to, their testimony is no longer admissible, and I'll explain why. So the first concern, prominent concern, is that Kayden's law requires that no treatment is provided for severe attachment pathology displayed as a child. Now, that's mind-boggling that the law would require no treatment for severe attachment pathology. But if you think about the borderline mom who's creating the attachment pathology, she doesn't want treatment. So she manipulated these legislator people to mandate no treatment. I'm telling you, the dark personalities are incredibly manipulative. And legislators have just been introduced to the vulnerable Dark Triad and the virtuous victim presentation. Oh my goodness. So let me explain why that is with the law. So here's what Kayden's law does is it restricts judges from ordering therapy to restore a healthy attachment bond to the parent. Any reunification services, notice how broad that is, reunification services. And Kayden's law requires the child to remain pathological. You're restricting and outlawing treatment because the borderline mom wants the child to remain pathological. So here's from the AFCC slide. Here's what the AFCC slide says. The Violence Against Women's Act includes a provision related to Kayden's law that provides a financial incentive to states to pass legislation restricting judges from ordering some reunification services. Specifically, reunification services must provide evidence of safety, effectiveness, and therapeutic value and may not cut off a child from a parent with whom the child is bonded or to whom the child is attached. So first off, that's going to require us to do an attachment assessment for all children in the family courts, mandated by the court. We have to find out if the child is bonded and attached or if that's an insecure attachment. And so we got to do an attachment assessment of all children in the family courts. Oh my goodness, no, you don't. You know, it's just the borderline mom. The moment you realize this is a borderline mom who's written this legislation, it all makes sense. Okay, so yeah, you can't take the child away from me. There's your abandonment fear. As long as they're bonded to me, which is the whole enmeshment and cross-generational coalition that they create. The child's bonded to me. You can't take the child away solely for, treating the attachment pathology towards the other parent that I'm creating in the shared delusion and false factitious attachment pathology. You can't treat a factitious disorder imposed on another. You can't treat my delusional thought disorder. Oh my goodness gracious. And the law and the state legislatures have passed this. Okay, my goodness. So a couple of things I just want to point out about this is that Kayden's law seeks to predetermine court decisions in favor of one of the litigants and prevents the other litigant, the normal range dad, from even presenting a defense. And we'll get into that in a second. Oh my goodness. But notice, just pull out a few things about that AFCC description. It's restricting judges. I do not like anything from the legislature that's restricting the judges. Okay, but that's a little concerning. From ordering reunification services, specifically reunification services. So that's a broad domain, and not cut off from a parent. So basically what we're looking at here is a borderline mother's abandonment fears. That's what it is. That's what just wrote that legislation, is the borderline mother's abandonment fears. It prevents reunification, which is restoration of a normal and healthy range attachment bonds to the targeted parent. It prevents that. And it prevents a protective separation of the child from a psychologically abusive parent. It is as obvious as the day is long. Kayden's law is, and here's the thing, here's one of the secrets that you don't realize. Kayden's law is actually the high road law. It's targeting one particular program for reunification, the High Road Workshop out of Dorsey Pruder and the Conscious Co-Parenting Institute. And I want you to note the law's requirements for Evidence of, now evidence. That's, pay attention to that word because I'm going to come back to it. Evidence of safety, effectiveness, and therapeutic value. So it's, okay, so that's the requirement here. I will argue, and quite strongly, that the high road meets those requirements. So here is data, here is evidence from the high road workshop that was presented to the American Psychological Association National Convention in 2019. Okay, so this is the evidence that the high road workshop, a 4-day psychoeducational workshop, is safe, it's effective, and it has therapeutic value. So let me explain what that graph is. So first off, is the high road safe? Yes. Is it effective? Yes. Has therapeutic value? Yes. Where's the evidence? You're looking at it right there. It's a single case ABA design. And what a single case ABA design is, let me pull that up and explain it. So there's 2 research designs that can prove causality. One is a randomized control study. The second is a single case ABAB design. Either one of those research designs proves causality. This is an ABAB single case design. We didn't need the second B phase because the child stayed recovered. When we took away the intervention, everything was fine, and the child stayed recovered. So there's 4 phases, but in this case, you'll see the first 3 phases because we didn't need the second B. The child stayed fine. So it's A, B, A. The A phase is a baseline phase. So it's no intervention. So what's the current situation? Then you apply an intervention, you see what happens, then you take the intervention away and it should go down, or does it stay there? And if it goes down, you put the B back in. If it stays there, you're good. And so this is an ABA single case design. It's a 15-year-old male. He was 3 years of documented child abuse. It was documented by 3 separate psychologists. 3 psychologists diagnosed the family with child psychological abuse. And it took the court 3 years with 3 doctors saying this is child abuse. It took the court 3 years to order that protective separation. Unbelievable that the court would participate in the child abuse, diagnosed child abuse for 3 years before protecting the child. And look what happens when this is a 2-day workshop, by the way. Let me explain where this workshop comes from and why it's a 2-day workshop. I was over in the Netherlands presenting, and I had asked Dorsey to come along and talk because she's got a workshop that solves it. And so we were over in the Netherlands, but she was getting ready to fly out. And she had been following this family for years, trying to get this high road and the protective separation for it. Because you need that protective separation. Because if you have an abusive parent and they're trying to create pathology in the child at the same time you're trying to restore the child, we're just going to rip the child apart. So the protective separation is not based on the high road. No. It's based on a DSM-5 diagnosis of child psychological abuse. So first, get your diagnosis of child psychological abuse. That's the only reason we separate a child. Physical abuse, sexual abuse, neglect abuse, or psychological abuse. Only reason we separate a child is a child abuse reason. Now, if you have a child abuse, then you get the separation, because no therapy of mine for physical abuse is going to be effective if I'm sending the kid home to be beaten with electrical cords. No therapy for sex abuse is going to be effective if I'm sending the child home to be sexually abused by a stepdad. No therapy for psychological abuse by a borderline mom is going to be effective if I'm sending the child home to be psychologically abused. And so the first thing we do with all diagnoses of child abuse is protect the child. And so you get the diagnosis of child abuse made by the licensed professionals. then you take the steps to protect the child. But Kayden's law stops that. It interferes. It says, no, you can't do that. And so we're going over to the Netherlands. But then the court orders the protective separation, finally. But she only has 2 days before she flies out to the Netherlands. So she adapted the workshop, normal 4-day workshop. She adapted it to 2 days and then administered it and flew out. And so this is a 2-day workshop. And look, I want you to notice what the data looks like. Now, the data is targeted parent ratings on affection, cooperation, and social involvement. So that top line up there, the silver one, is social involvement. The gold line in the middle, that starts in the middle, is emotional regulation, or is cooperation. That's your emotional regulation networks. And the blue line, which starts off at the bottom, is the affection. That's your attachment networks. And so the baseline phase there is the A. The high road is the B phase. So that middle phase right there, where you see the child going from 1s and 2s to 6s and 7s on affection, cooperation, social involvement, ratings by the targeted parent. So you know these are accurate. They have no reason to falsify data. They're saying, no, this is in the workshop, 2 days. And by the way, Dorsey collects this data on all her workshops. So there's your demonstrated, evidence. She's got the evidence. She's got the data from every single workshop. So in 2 days, look at that rocket rise. Now, the second part, that second phase, is the post-workshop therapy. And that indicates it's a stable recovery. Look, it's going up and down, but it never dropped back to the 1s and 2s. That she got a stable recovery. And you see that flat line area where it says the 1 and the 2 in the circle? That's because I'm the therapist for this. Over in the Netherlands, she said, I just did a workshop. Would you be was in Los Angeles. She said, would you be the treatment, the follow-up care provider? And I first said, no, I don't want to. But she talked me into it. So, but we were in the Netherlands. So I started around that 4 and 5 point. That's where you see my therapy begin. And all those little points are different points on the therapy. I think are really cool. But that stable period means that this mom and the boy maintained their recovery without any intervention for weeks until we got the reunification or the follow-up therapy, my follow-up therapy in place. So it was the easiest case I've ever had because I had a recovered child. Everything was fine. He was fixed with his mom. And so I just kind of stabilized it, worked out a few things, and gave some relapse prevention stuff for going forward. And it was easy peasy treatment. So I want you to notice, that's the High Road Workshop. You want evidence of the effectiveness of the High Road Workshop? There it is. Look at that. 2 days. And everything's solved. And the idea that Kayden's law is seeking to prevent this and prevent parents from having access to this intervention. Now, let me also explain. So not only did I receive a client from the High Road Workshop, I have personally observed all 4 days of the workshop. So I have sat in on a workshop and observed what's taken place. I have reviewed the protocol for the workshop. Okay, so I've seen what she's done. And we presented what the protocol is, what the High Road does at the AFCC National Convention in 2017. Dorsey and I went back there. I presented on the shared delusional disorder. Then we jointly presented on what the High Road is, what it does, how it works. And I have those slides. I can do that anytime anybody wants. I can tell you exactly how this works and achieves its effectiveness. It's not a therapy. It's not a therapy. No therapy can do this. We don't have a single therapy that is 4-day for anything. It's not a therapy. It does something different. And it's gentle. It's effective, amazingly effective. And it's quick, easy. Okay. Now, if you believe that I'm lying to you and that I'm out to abuse children and Dr. Childress, you're part of that delusional thought disorder. No, I'm not. I have no business associations with Dorsey. Dorsey's a coach. I'm a licensed psychologist. We're not on the same level, and typically that's a problem. The licensed psychologists are not really happy with unlicensed coaches. So there's not a whole lot that would motivate me to say, oh, Dorsey, and promote her. We have no business associated, nothing, except look at that data. Look at it. 2 days, she got a full and complete recovery on this. Holy Toledo, she's the real deal. And that's why the borderline moms want to stop this. They've been going after her for decades. She's been in the family courts for decades. She's the most experienced professional in the family courts, and they're trying to stop her from solving things. So that's just one point. So this is not actually Kayden's law, it's Dorsey's law. But here's my assertion. As a clinical psychologist in the family courts, and you know me, I'm banging on the forensic psychologists, banging on the parental alienation experts, and yet with Dorsey in the High Road Workshop has my full endorsement. It is safe, it is effective, it has therapeutic value. Dorsey Pruder's High Road Workshop meets the requirements of Kayden's law. Okay, so that's, sorry, Pathogen, you missed. Okay, you can get Overcoming Barriers or Turning Point by Gottlieb. Yay, good. Overcoming Barriers by the forensic psychologist. Their 4-day entry into the workshop, complete failure. I know, I watched it come, I watched it go. And it's like, so the forensic psychologists will talk about overcoming barriers. They have no idea what they're doing. But Dorsey, absolutely right on. So, Kayden's law is designed to prevent effective treatment and restoration of a healthy parent-child attachment bond, not just by Dorsey's program, by any treatment. So here, going back to the AFCC slides, here's the slide that talks about the definition of reunification treatment under Kayden's law. The term reunification treatment means a treatment or therapy aimed at reuniting or reestablishing a relationship between a child and an estranged or rejected parent or other family member of the child. So even the grandparents. So notice they are saying they are restricting all forms of treatment designed to reestablish a relationship with the child with another family member, their grandparent, their parent. Nope. We cannot treat attachment pathology. There's your borderline mom's abandonment fears. She's creating pathology in the child. She's using the child as a regulatory object, and she does not want us to get rid of the pathology because she needs that. And so she's manipulated the legislatures to do that we cannot treat the delusional thought disorder. We can't. By legislature in certain states, you cannot treat delusional thought disorders imposed on the child. You cannot treat a factitious disorder imposed on the child. You cannot treat child psychological abuse by legislative mandate. Wow. Okay. So, all normal range parents, this is just something, just understand. Oh, man, this is so obvious. All normal range parents want effective treatment. Okay, if your child has a severe attachment, but you want that treated, you want that child to have a healthy, normal range childhood. However, Kayden's law is designed to prevent effective treatment and restoration of a normal and healthy range attachment bond in the child. Kayden's law requires that the child remain pathological. That's what I say. The legislators are participating in the child abuse because they've been manipulated by a vulnerable dark triad. Welcome to the world of the family courts legislatures. You just met the vulnerable dark triad. So here's the second issue. Kayden's law requires that no treatment is provided specifically for child psychological abuse. Okay. So we can treat physical abuse, we can treat sexual abuse, we can treat neglect. However, Kayden's law prevents us from treating psychological child abuse. Nope, 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 nope. We can't treat that. That we have to allow the child to be psychologically abused. So here it is. A purple thing is from the AFCC slides. A, no removal or care from a safe parent. Okay. I would argue that a psychologically abusive parent's not safe. So as soon as we get the diagnosis of child psychological abuse, we can protect the child. Okay. But notice the safe, everything's safe, everything's danger, safe. Is child safe? That's a persecutory delusion. Okay. You're responding to a psychotic disorder in a borderline mom who sees dangers where none exist. And so she's going safe. Everything's safe. No, the child's okay. The child's okay. If you're worried about safety, we'll do an assessment on it. We'll look at the targeted parent. Are they abusive? And then we'll look at the allied parent. Is this a persecutory delusion? Safe. Okay. So here's what it says. No child shall be removed from the care of a competent, protective, and non-physically or sexually abusive parent or litigating party to whom the child is bonded or attached. So notice they say from a physically or sexually and omit psychologically abusive parent. So you want to correct Kayden's law? Add psychological abuse to it. That we can protect the child from physical abuse, sexual abuse, and psychological abuse. Easy peasy, legislators. Add the word psychological abuse in there so you won't be manipulated. Dad groups, oh my God, you need to get to your legislatures and get psychological abuse on that. And it's omitted for a reason. Don't you find it a little odd that they would omit psychological abuse and include the other two? Because the borderline mother is psychologically abusing the child. She is creating a shared, induced persecutory delusion and false, factitious attachment pathology in the child for secondary gain to her. She does not want the child's psychological abuse treated. She wants her allegations of physical and abuse and sexual abuse to get all the focus. She doesn't want anybody looking at what she's doing and the false allegations of child abuse, the false allegations of physical and sexual abuse. Now, here's the second part of that. Any order to remediate a child's contact resistance, so any order to treat the child's attachment pathology, must address the resisted parent's behaviors or contributions to the child's resistance first, before ordering the preferred parent to take steps to potentially improve the child's relationship with the parent they resist. So we cannot treat the borderline mom's pathology. We have to treat her delusional fears about the dad. Oh, he's vegan. No, he's not. Well, you have to do that first before you can look at anything else about looking at restoring it. He has to get into therapy, and it's manipulative. Oh my God. This is the one, you dads in the family and your dad's groups, you need to get on this, because this is preventing any therapy for anything other than you, and because of her persecutory beliefs. Okay, that's just, these legislatures are participating in the child abuse because they've been manipulated by a vulnerable dark triad. And so here's from the research literature. Barno et al. This review, they did a meta-analysis of all the research on borderline personalities, meta-analysis in 2019, and here's what they came up with. This review reveals that psychotic symptoms in borderline personality disorder patients may not predict the development of a psychotic disorder, but are often permanent and severe and need careful consideration by clinicians. Therefore, adequate diagnosis and treatment of psychotic symptoms in borderline personality disorder patients is emphasized. So, what are these psychotic symptoms that show up in the borderline? In conclusion, we therefore suggest that it is not a cognitive developmental deficit, but rather a tendency to construe interpersonal relationships as malevolent that characterize borderline personality disorders, and this may be shared with certain psychotic disorders. A persecutory delusion, that is what they're talking about. The psychotic disorder is a persecutory delusion, a thought disorder. And it's the definition of a persecutory delusion from the American Psychiatric Association. Persecutory type, delusions that the person or someone to whom the person is close is being malevolently treated in some way. Malevolently treated. This is a delusional thought disorder, and the legislators are participating. They believed a shared delusion and become part of the child abuse. If you believe a shared delusion, you become part of the shared delusion. The final piece I want to cover is that Kayden's law restricts expert testimony to only the experts of the borderline vulnerable dark triad parent, only those domestic violence experts, that they want to call, but it restricts all the other experts. They are prevented. So the fathers in these custody litigations have access to no expert testimony, no defense. They can't even say, well, treat the mom. No, we have to treat you fully before we can even address the child's resistance to you. It's like, you guys are done. Okay, you dads in the family court, your goose is cooked entirely. So let's take a look at that. So, and this is the interesting one, because the forensic psychologists are banned from providing expert testimony because they do not have demonstrated expertise in clinical, not solely forensic experience with domestic violence and child abuse. So here's the purple box from the AFCC presentation. The state has in place, this is a requirement to get funding, that the state has in place a law ensuring that in custody proceeding where a parent has been alleged, just alleged, not proven, just alleged to have committed domestic violence or child abuse. Let me bring that up for a second. Notice how they put domestic violence first. No, it should be reversed. We should be protecting the child because it's a custody situation. But notice an allegation of domestic violence is all it takes to trigger this. This is just written by the borderline moms. Holy Toledo. So just a mere allegation of domestic violence, including child sexual abuse, that evidence from court appointed or outside professionals regarding the alleged abuse may be admitted only with the alleged abuse. The alleged abuse may be admitted only when the professional possesses demonstrated expertise and clinical, not solely forensic, experience in working with victims of domestic violence or child abuse, including child sexual abuse. So it specifically says not solely forensic. It has excluded, because all the forensic custody evaluators, that's all they have, is the forensic experience. They don't have clinical experience in child abuse and domestic violence. They're working in the family courts. So they are now no, their evidence is no longer admissible. I don't care if they're court appointed, they can't testify because they don't have clinical experience, even if they're court appointed. This is a nightmare legislation. Holy Toledo. It's going to chew up the court system, and the parents are going to, it's going to chew up families. It's just so ill conceived by a psychotic borderline mother who presents as a virtuous victim and manipulated the legislature because they don't know what a vulnerable dark triad looks at. That's why it's important to have competence. If you're not a psychologist and you're not competent with the dark personalities, you shouldn't be working in the family courts. And if you're a legislator or an attorney or a judge who's working with these type of pathology, people, dark triad, vulnerable dark triad, dark tetrad, you need to get some mental health consultation on this. We need a diagnosis on this because they are extraordinarily manipulative. And look, this is a slide from the forensic psychologist. And so Kayden's law is flawed premises. Oh, they just do not like Kayden's law at all for a variety of reasons. Danger, false premise, because they're getting excluded from the family courts. Yikes, cowabunga. Now, I agree that you need clinical experience with child abuse. Now, you can get that in a lot of ways, but you can get consultation on that and stuff. But you need to be competent with attachment pathology, with child abuse and complex trauma, with family systems, with delusional thought disorders, dark personalities. There's a lot of things you need to be competent in. So I kind of agree that the forensic psychologists need to go, and we need to get back to clinical diagnostic assessments. But it kind of amuses me to see how distressed they are. And that means they're going to be going back to the legislatures here to get adjustments to this because they've just been banned from the family courts in all those states and in future states that pass Kayden's law variants. So, and the borderline moms got this through with secret, and the forensic psychologists had no idea it was there. And so they bought 15 slides about how it has false premises and stuff going forward. So now, interestingly, I just want to point out, Dr. Childress meets Kayden's law restrictions, that I have demonstrated expertise on my Vita, not and clinical, not solely forensic experience with child abuse and intimate partner violence, not domestic violence, intimate partner violence, IPV, because there's multiple types of IPV. And my experience, demonstrated expertise, is I was the clinical director for a 3-university diagnosis and assessment center for children ages 0 to 5 in foster care. Child Protective Services was our primary referral source. So when CPS took a child out of the home, put them in foster care, they then sent the child to my clinic for diagnosis and treatment. Okay, so I have demonstrated expertise, clinical director level, in clinical treatment, diagnosis and treatment of child abuse, all 4 forms. I personally treated all 4 forms of child abuse: physical, sexual, neglect, psychological. I have personally led the treatment teams that have included CPS social worker involvement for all 4 forms of child abuse, plus I've taught it and supervised the interns and everything. So I meet Kayden's law restrictions. None of the forensic psychologists do. PAS experts have been banned from the family courts by Kayden's law. So you don't have any experts in the family courts other than the borderline mom and her domestic violence experts that she can call in about how bad domestic violence is for children and stuff. And you can't do anything. You can't defend yourself by statute. You're not allowed to present any expert testimony. You're not allowed to treat the pathology. You're not allowed to. Yeah, you've been played by a borderline mom. Oh my goodness, you folks. So with that, I would just pull up my business card. Notice I've gotten licensed in 3 states now. So I'm licensed in Washington, I'm licensed in Oregon, and I'm licensed in California. I'm not accepting clients from Oregon, so I'm not consulting with any attorneys, parents, or mental health people from Oregon. I got licensed in Oregon just simply to put that whole Oregon sanctions to bed. Okay, practice in Oregon without a license. Okay, I'll get a license in Oregon. That's not the issue. The issue is the child abuse by the forensic psychologists in Oregon, and the covering that up and the covering it up across all of professional psychology. So, and the other thing I just want to point out before is I'm on Blue Sky social media, and I post about the pathology every day on Blue Sky. Those little nice little things. So if you are an attorney, family law attorney, or mental health professional, parenting coordinators, judge, GAL, anybody in the family courts, parents, anybody in the family courts, follow me on Blue Sky, and I will be providing you with information about the nature of the pathology. So with that, I'm going to go off to my Sunday here, and good luck, everybody. And you need to get on Kayden's Law. It's going to come around for a second revision because the forensic psychologists are not happy. So the AFCC will start to put their lobbyists in, and that's a good point when you also come in with your considerations. New Mexico is working on a good law. So if New Mexico can generate the proper adjustments to Kayden's Law, then the other states can follow that model statute to get a balanced legislation that doesn't just roll over to the borderline vulnerable dark triad and bias everything against a normal range dad. There's two variants of the pathology. A narcissistic dad variant, that's your dark triad, the borderline mom variant, vulnerable dark triad. And it's not exactly gender-based, but you can think of it that way. And it's a very malevolent, dark personalities. The really scary one is the dark triad dad, because he's got the psychopathy, who's a dark tetrad. You add sadism to that. Narcissistic, psychopathic, manipulative, and sadistic. And you've got that in the family courts, and you're not doing anything about it. Oh my goodness, that's the other version. That's the normal range mom and the dark triad dad. This is the vulnerable dark triad mom and the normal range dad. We just need balance in the family courts. Let's get a diagnostic assessment, diagnose what it is, and then we'll know how to treat it. So with that, good luck, everybody out there. And you know where I am. I'm an expert under Kayden's Law, and I'm an expert in real life, and so I'm here to help anybody who wants to solve this. I'm available.